Well, good afternoon, everyone, and I just want to thank everyone at AGF for having us and giving us this time to talk about what we're very excited about is this project that we have titled Return My Vote. And so I'll just introduce myself. I'm Richard Fording. I'm a professor in the political science department at the University of Alabama, and I've been the campus champion for our chapter Vote Everywhere for several years now, ever since we've had one, actually. And Sam, go ahead and introduce yourself.
Hi, all. I'm Sam Robson. I'm a junior at the University of Alabama. I'm also the incoming team lead for Vote Everywhere at the University of Alabama, and I was an ambassador this last year, and I am a project assistant on Return My Vote, I believe is my official title.
Yes, it's a work in progress. Sam is one of the four primary people, really one of the four only. There's really four of us who run this project right now, and Sam has played a key role from the very beginning. There we go. And you can see that, Return My Vote. There's our leadership and our advisory board. We're a partnership between faculty and students at the University of Alabama. The students largely going to be Vote Everywhere students, and the community, different people who are involved in different community groups that have some interest in voting rights restoration. Sometimes it's through their work in the reentry population. Sometimes it's directly through more general work on voter mobilization, but they're all united by the interest in this issue. And so the mission of Vote Everywhere is to help anyone in the state of Alabama understand their eligibility status if they've been convicted of a felony, and especially then to help them understand what they need to do to be able to register to vote, assuming that is possible, if not now, at some day in the future. And so we do this through a virtual platform that we created. And so this is one of I think the real novel thing about our project is that we allow people to contact us and request a consultation. You can go to our website and you can see how that's set up. You can click on the request a consultation button and you can see, read about that. And so we offer, different ways of communicating, whatever is most convenient or desired by the client. And then what we do is we take their information and we look them up in a database, the criminal records database of the state of Alabama, which we subscribe to. And then we explain to them basically what their status is and what they need to do and how we can help if we can help. And so as you'll see, this is in Alabama, but also in a lot of other states. This is a very complicated process. The law is very complicated. And so we're going to start with then sort of an overview, sort of historical background on the history of what some people call criminal disenfranchisement laws. Why do they exist in the first place, or at least what's the rationale historically? And then we'll sort of move through to, sort of contemporary history in the United States. We'll move to the case of Alabama as sort of a case study in the complexity of felony disenfranchisement laws, and also the barriers to rights restoration, which will lead us to also talk about the sort of the complexity of understanding and helping people get their rights restored. So most people are used to hearing the term felony disenfranchisement, but in sort of the legal and social science literature, when we're thinking about this in a broader kind of international context, the term criminal disenfranchisement is often used. So it means the same thing. And I'll just say that, the US is, as it is in many things, an outlier compared to other democracies, in that we're one of the few countries that disenfranchises people when they're not incarcerated due to a crime they committed that led them to be incarcerated. In almost every other democracy, the policy decision, there in those countries is whether or not people convicted of those potentially disqualifying crimes can vote or not while they're even incarcerated. In other words, whether anyone is ever disenfranchised due to some type of crime. But in the US, we go beyond that, and in almost all states, or majority of states, there's some disenfranchisement that happens depending on the law. So the origin historically for the rationale, if you go way back, this is an idea that goes all the way back to the very early days of democracies in ancient Greece. The idea basically is that there are certain rights and obligations of citizenship, and that basically obeying the law and obeying the government is one of those obligations. And if you don't do that, if you break the law or certain laws, then basically you're deserving of losing those citizenship rights broadly, and voting then being just one of them. And so the concept, over time, and going to medieval Europe was civil death. And it again, there are also other rights that you lose today potentially when you commit a serious crime. And so this notion of civil death goes all the way back to the very origins of democracies. And it was, the rights you would lose, were much more severe than they are now. But that's sort of the logic, the basic logic of it is that here we've got some quote from John Locke. Some of the democratic theorists that we look to, that were important in sort of the design of our democracy, even, agreed that there are these rights of citizenship that people, have the privilege of exercising, but there are these obligations that must be met as well. And so that's, again, sort of the rationale. And you can see what Locke said here. Criminals follow not the law of reason, but that of force and violence, and so may be treated as beasts of prey. This argument continues to be made today. And sort of a related argument also is that, well, if we didn't disenfranchise people who have committed serious crimes, they would vote and basically, influence our political system to basically make these serious crimes, no longer criminal. That's called the subversive voting argument, is basically if we let all the quote unquote criminals vote, that, they would basically undermine the rule of law through their influence in the political process. Of course, we don't believe that to be the case. But that is still an argument you hear today. Many of you may be familiar, or at least associate felony disenfranchisement with race and sort of the long, dark, history of race politics in this country. And of course, that is true. We just wanted to, make the point that these laws existed prior to sort of the voter suppression of African Americans, purpose that they eventually took on. That didn't happen really until the late 1800s, after during Reconstruction, African Americans, and the passage of the 15th Amendment, and African Americans, at least African American males were at least legally, according to the Constitution, allowed to vote and enjoy all the rights of citizenship. And so, of course, we know that that was not adequately enforced at all. And one way that this was subverted is through state constitutions that were rewritten at the time, which explicitly changed, the voting eligibility laws to make it so that people who committed crimes, especially crimes at the time that were associated with African Americans. That would, this was sort of a race neutral, at least from a legal perspective, way of doing what they wanted to do, which was to preserve white supremacy. And that that's not an interpretation. That was made clear in many of these transcripts of these conventions. And of course, it was this same motivation that was behind the murder of Goodman, Cheney, and Schwerner in 1964 in Mississippi. And so we kind of continue along that path here in the Deep South. There's a lot of work to still be done, and felony disenfranchisement continues to operate as an important, significant mechanism of voter suppression of African Americans. So one of the reasons that this is such a difficult law to overturn, and why a legal strategy has been ineffective, is that in the Constitution itself, and this is from the 14th Amendment, there is language that has been interpreted by federal courts since to essentially allow for states to disenfranchise people based on crimes they've committed. And that's that section down there, the last part, except for participation in rebellion or other crime. And so that's been cited, many times as, basically giving states the right to disenfranchise people. And so it's been, even, in the case where the disenfranchisement has been implemented with very glaring, severe racial disparities, it just, these cases don't get decided or examined at the level of scrutiny that would allow them to be overturned, simply because of the fact, or in one part because of the fact of this language in the 14th Amendment. Go ahead, Sam.
Sorry, it took me a second to unmute there. Yeah, so we kind of hit our first legal implementation of felony disenfranchisement in Alabama as far back as 1875. So like hot off Reconstruction right here. And they essentially tried to target crimes that they believed to be more frequently committed by Black people, or where there were more convictions for Black people. And the Alabama Supreme Court first ruled in on it and said that they were perfectly fine with it because political suffrage is not an absolute or natural right. In fact, you see like in all of these cases that there's just a brazen admission that voting is not actually viewed as an absolute right in this country, and that is the only legal basis for felony disenfranchisement. And it's unfortunately been upheld time and time again. The US Supreme Court in Richardson v. Ramirez said similarly that it is, it doesn't matter if you break the law, you've broken your obligations to society, and therefore you don't get to participate in the franchise anymore if states say that.
And so here are some sort of a timeline of the impact of these laws. And so a couple points to be made here. One, if you just sort of look over time and you look at the sort of the trajectory of, the line in the graph there, you can see that it, of course, tracks pretty much with the rise in mass incarceration in this country. And of course, that makes sense. And so that's one reason why it's become much more significant issues, because so many more people now are affected by these laws because of the rise of mass imprisonment. You can see there that so I think consistent with sort of a more recent kind of success of progressive criminal justice reform, there has been a decrease in the number of people impacted by these laws because some states have reformed their laws. But that one thing I want to make very clear is that this does not mean that 1 million more people are voting as we go from 6.1 million to 5.1 million people affected. This is simply an estimate of the number of people who are ineligible due to these types of laws. And of course, as you probably know, there's significant variation across the states in the design of these laws. Much of that disenfranchised population comes from just a handful of states, actually 11 states here, that have the most severe or the strictest disenfranchisement laws. And those are laws that do not allow someone, once they've been convicted of a crime of moral turpitude, as it's called, a disqualifying crime, the strictest laws do not allow you to be eligible to vote again until you've completed every part of your sentence, including any type of supervision after you've been released from prison, as well as repaid all fines and fees associated with the disqualifying conviction. And that last part we'll talk about more in a minute. If you look at the impact, it's significant overall, nationwide, but it's especially glaring, I think, in the states with the strictest law. So there are 7 states here that we've pointed out. And again, this comes from the Sentencing Project, which does the best and actually the only work that I'm aware of in coming up with these types of estimates. They estimate that more than 1 in 7 African Americans is disenfranchised in these 7 states, including Alabama. And think about that for a minute. If 1 in 7 African Americans, that's about 14%, but about 90% of the prison population is male. And so what that means then is that we have much higher disenfranchisement rates for African American men. It would have to be at least 20+% based on these estimates. So mentioned previously, and we can go over this quickly and get to our project, but the historical origin in Alabama came with the 1901 Alabama Constitutional Convention. And here's an example of a transcript from that convention where it was just made very explicit that the purpose of, sort of revising these laws was to serve the goal of, establishing and maintaining, preserving white supremacy. And so they did this by having this law which identified crimes involving moral turpitude, but it was basically just an opening for the criminal justice system and the basically the voter the election administrators to disqualify African Americans based on the crimes that were committed disproportionately by African Americans, or in a lot of cases, it turns out, it was decided at the local level. And you could imagine, different types of enforcement based on the racial makeup of each county. Go ahead, Sam.
Oh, I thought you meant the slide. I forgot this one was mine. Sorry. So you see like these not very serious crimes, like presenting a worthless check, falling in the original standard for moral turpitude. This is going way back to 1901. But then you see more serious offenses that just aren't committed by Black people as often, not considered. And by 1903, so this is 2 years after the second implantation of moral turpitude disenfranchisement in Alabama, you have 10 times as many Black people disenfranchised as white people. So John B. Knox kind of got his way in securing white supremacy in the state. And as recently as 1985, Hunter v. Underwood kind of says that while it is unconstitutional, it was only unconstitutional because of the explicit racist language used in the transcripts. So the decision in 1985 that the Supreme Court made that shot down the moral turpitude provision was more based on what John B. Knox and others said than the actual consequences. In fact, it was explicitly not based on discriminatory effects of the policy, only explicit intention, which is not the strict scrutiny standard that you see being applied in other voting rights related cases because of the 14th Amendment example. And we got rid of it for 11 years, and then they figured out a new way to bring it back in 1996. And this is the current version of moral turpitude law that we have in Alabama today. And it says that no person convicted of a felony involving moral turpitude or who is mentally incompetent shall be qualified to vote until restoration of civil and political rights or removal of disability. At the time of its passage, there was no definition of a felony involving moral turpitude. So they actually just expanded the vagueness to remove the allegation of picking crimes that were more likely to be committed by African-American residents. And then just sort of gave the power to the registrars, which did not go well, as you can imagine. Dr. Fording, is this your slide?
Yeah, I can take it. I can take this one. Yeah. So what we had up until 2017 then was we had the reinstatement of felon disenfranchisement laws in Alabama, but because of the vagueness of the law, it allowed county election offices, the voter registrars, basically to kind of decide what a crime of moral turpitude was, and it varied from place to place. And that was obviously a problem. The Alabama, the Secretary of State of Alabama recognized that. There was some pressure from the federal government, potentially looking at a lawsuit that, of course, would have been very successful. And so the state of Alabama passed legislation that finally, explicitly laid out all of the specific crimes that they deemed crimes of moral turpitude. And so, some people thought the list that was produced should have been shorter. Some people thought it should, have been longer. There are actually a number of crimes that were being counted as moral turpitude crimes prior to 2017 that did not end up on the list. And so in some ways, I think it was a victory for people who feel that this law is too harsh, but it also is the reason why this is so confusing now, because you have, very specific laws identified as being crimes of moral turpitude and disqualifying, and some that aren't. For example, burglary in the second degree is disqualifying, if I'm correct, Sam, and burglary in the third degree is not. Actually, most drug crimes now that are classified as possession are not disqualifying, but then there are other types of drug crimes that are. And so this law, while helpful, has created, though, a lot of confusion. And actually, most people, I would say the vast majority of people who have been convicted of felonies do not know what the law says, and they assume that they're disqualified, even though, most of them probably would not be. Okay. Yeah. So, and this is sort of be the last thing, then we'll move on to our project. Is another example of why it's so difficult to get your voting rights back in a state like Alabama, and other states do this too, is that there's this extra step you have to go through to become eligible to get your voting rights restored. And so, if you've been convicted of a crime that disqualified you, and you don't have any other pending criminal felony charges, you paid off all your fines and fees and completed every aspect of your sentence, then you are eligible to submit an application for what's called a certificate of eligibility to register to vote. And that goes to the State Board of Pardons and Paroles. There's a special form you have to fill out, a special place where you have to go on their website to download the form. And then you have to send it to a specific office, and then you have to wait, and they look through it. And then they send you back this certificate, and then you take that to your local election office, show it to them, and then you'll be able to register to vote. So it's this extra step that a lot of people don't know about or understand. And of course, there's all these other conditions of being eligible to be reinstated, which is especially complicated with the fines and fees. And Sam will talk about that here in a second. And so it's just such a messy process, and so opaque for most people that we see very few people who have been convicted of disqualifying crimes and become eligible actually pursue this process and get their rights back. And that's why it's so important that people be working, on the ground, like we're trying to do, to reach out and help people learn about their status and then learn about the process to get their rights restored. Go ahead, Sam.
Awesome. So now we're going to talk about some of the main barriers that we see to rights restoration in Alabama and other states in the context of our project. So we'll talk about the problems we see, how we've gone about addressing those, and what we think that might look like in some other states. Huge one in Alabama is eligibility notification. So some states, whenever they've gotten rid of their felony disenfranchisement laws, they've had mandatory reporting to let people know who are now eligible about them. In Alabama, not only was this not mandatory, but the Secretary of State never even put a press release up on their website or gave trainings to the registrars who were supposed to implement this new policy. I think that there's like a one-page little thing that's hanging up in each jail and frankly has outdated information on it that they have to put up. And you can see that in this table. I mean, like, Alabama has fairly restrictive felony disenfranchisement laws, but not the worst. But you see this very, very low number of restorations, about 3,500, whenever, based on the data we see on people in the criminal justice system and people coming out of it, hundreds of thousands should be eligible. And the only conditions to become eligible are things that people are already incentivized to do. There are other reasons you need to pay your fines and fees off, or it can become very difficult, so people just don't know, we think, or can't go through the process. So yeah, the Sentencing Project estimated that 286,000 ex-felons had completed their sentences, but still could not vote in 2016. So that's obviously a year before the definition of Moral Turpitude Act came out, but we've had, you can count on one hand the number of thousands of restorations we've had since then. And you also see widespread evidence that people just don't know that they can vote. It's not the only issue though. Alabama is one of a couple states that requires that you pay off all fines, fees, and restitution on your disqualifying offenses before you can get your voting rights back. That is a bad thing, we believe, because rich people can do that much, much easier than poor people who are re-entering. And in Alabama, for example, the median legal financial obligation in 2015 was $1,800, and it doubled between 1995 and 2005. That's a trend you're seeing continuing. The Alabama Unified Judicial System is worryingly dependent on fines and fees to operate, which incentivizes like constant raising of fines, fees. You'll get charged $30 for a piece of paper. Every single thing gets paid out there, and it doesn't get put in a publicly accessible database unless you pay money, which is also something that what we do. So it is very much the case that most people cannot determine their eligibility without help from a partner like us, or without paying money for multiple public records that pertain to them and how much money that they might owe in a certain case. Yeah, which is why the fines and fees aren't getting paid off. And yet we still see in Thompson v. Alabama that this is not considered a poll tax because it's, their fault under, how criminal law works, because for the same reason that their voting rights can be taken away in the first place, they can have these really cumbersome, arcane processes that discriminate in multiple ways. And finally, there is the pardons and paroles process. So you must finish any parole or other requirement on your sentence before you're eligible for voting rights restoration in Alabama. A lot of other states have a policy like that. You can also sort of shortcut that process by getting a pardon. That's the only case where you can pretty much always get your voting rights restored. But the state doesn't really award pardons. In fact, it's even difficult to find where they have. They're several years behind right now, according to certain court records. And they grant 27% of pardon applications in 2021. And when you look at that 79% figure 2 years earlier, you can kind of see how politics plays into it. The board is a board of 3 people, all appointed, I believe. And they get to just kind of choose. It's discretionary, just like the registrar moral turpitude provision was, and you have predictably discriminatory effects because of that. And it's also just really, really complicated. Some of the questions on this screen, we don't even know the answer to this day because it's not settled law. We think that it should be at absolute minimum the burden of the state to find and register voters who have been disenfranchised through these policies and through these policy changes, or at least to clarify what its own law means. But instead, anytime that there's a request for clarification, literally going back for 120 years now, it's just ended in a lawsuit and no more clarification. There is a certain type of fine that you don't actually have to pay before applying. It's D999 interest. None of the forms that you would see online mention anything about it. There's a form called a fine reprioritization form, which you have to fill out to select which fine you want to pay off first. Otherwise, the state will automatically pay off the fines that don't help you get your voting rights back first. Like that, it's their policy to do the ones that don't help you first. I didn't even know that form existed until like 2 months ago. They try and make getting your voting rights back like canceling your cable, and it's legal for them to go about it that way, which is a very big problem. So big that we estimate that 8% of Alabama's voting age population is disenfranchised because of this policy. That's a massive number. I knew that voter suppression was real in the South before I came here, but even people who are really involved on this issue, I've met that just did not understand the full impact of these modern policies. They are competing in efficacy with pull tests and other similar technologies of the past that have since been abolished. But this criminalization and stigmatization of criminality has proved a very persuasive way to keep these policies in check. And the language of the 14th Amendment essentially makes it so that our only tools are to help those affected by the policy and to advocate for legislative changes at the state level. So that's kind of what we do. Like I said, you cannot check your own fines and fees by yourself in Alabama, except for through this one site, and it costs like $12. It's called Just One Look, and no one knows about it. And it looks like it was made in the 90s. But there's also this subscription service called Alicourt. It's several $100s a month, but it gives you full access to their online judicial databases. We secured grant funding through our university, through a competition, through the Blackburn Institute. I mean, we've sought money from multiple places at the university and gotten it from pretty disparate places. You really got to look around and kind of get creative on where you look for funding for stuff like that. But come with a project whenever you're asking for funding. It works a lot better, I'd say, on that. And then we have a website. People sign up for us. We also do in-person tabling events and partnering events through clinics. we search people and we determine whether they're eligible to register, and we'll help them through the registration process if that is necessary. And this is all student run. So we have Dr. Fording and our community partners. We have really a network of voting rights restoration experts that we're really fortunate to work with. But the basic at the groundwork level can really be done by anyone with training. So sort of our project is to figure out how many students we can train and whether it works. And I think we've been successful in that so far. But yeah, we want to see this type of rights restoration work happening all across the United States, not just Alabama. And we think that our model is sort of adaptable to other states. I'll speak on, I was going to say, I thought there was a slide that got skipped. And just like sort of our pitch for what we actually do, we run a website, which can be difficult in some ways, but we're mainly using like software that our university gets for us for free to run it. We're just using like normal scheduling software to link students to people who are consulting. Our marketing is like all through social media. Follow us at Return My Vote, by the way. And then we expand through community partners. And that's really, really, really important for us because we do not know the community that we're trying to target very well, or at least nearly as well as our community partners. So we view ourselves as a resource to them. And our job is to make other people's lives easier. So we wanted to consolidate all of the rights restoration know-how, see what can be applied at the student level, train a bunch of students, have them run consultations, and get some folks registered to vote again. And that is a pretty wide effort. The Campaign Legal Center has a project called Restore Your Vote that has an online type of wizard to see the rights restoration process in your own state. And that works in any state. I highly recommend you that you check it out and see how the rights restoration process works in your state and learn the policy. Usually the issues are awareness, not difficulty. It takes about 20 minutes of explanation in most states for someone to understand it, but that is just way more than you can get out of hundreds of thousands of people in the reentry population. So work through partners, because voting is not the most important thing on people who have just gotten out of prison's mind. Housing, food, employment, all of that. But if we can work with partners that provide those things and are trusted resources, then we can take some weight off of their shoulders. And also we don't run the risk of offending anyone or doing anything that we later find was not ethical for a reason that we could not anticipate. So yeah, and we want to make this a thing everywhere. We think Alabama is one of the harder states to implement this in because they don't really tell you what the law is and don't really know what the law is. So it's very much a figuring things out scavenger hunt, but not every state's like that. So I think if we can do it, anyone can do it, and we'd love to partner with anyone who likes to. Thanks.